In 1946, 11 nations that had been at war with Japan established at Tokyo the International Military Tribunal for the Far East, or the IMTFE, pursuant to the Instrument of Surrender signed on the deck of USS Missouri at Tokyo Bay on the 2nd of September 1945 by the representatives of the Japanese and Allied governments. The IMTFE was modeled on the International Military Tribunal at Nuremberg, or the IMT. The IMTFE was tasked with determining the accountability of those Japanese whom the Allied authorities identified as principally responsible for the commission of aggressive war, or then known as crimes against peace, war crimes and crimes against humanity in the Asia-Pacific theater since around the Japanese invasion of Manchuria in September 1931 to the cessation of hostilities in 1945. The Tokyo Tribunal received evidence against 25 individual accused. They included General Itagaki Seishiro, one of the co-plotters of the invasion of Manchuria, General Tojo Hideki, formerly Prime Minister and concurrently Army Minister for much of the Pacific War, and Marquis Kido Koichi, the Lord Keeper of the Privy Seal and a personal confidant of the Emperor of Japan, Hirohito. Emperor Hirohito himself, as some of you may be aware, was named neither as an accused nor as a witness due to a high-level policy decision adopted by the Allied authorities in early April 1946 not to have the Supreme Commander for the Allied powers represented in occupied Japan take action against the emperor as a war criminal without further authorization. It remains a matter of controversy as to whether or not the Allied powers should have put Emperor Hirohito on trial. The Tokyo proceedings lasted for 2.5 years, with the result of split decisions between the majority of 7 justices and 5 justices who submitted separate concurring and dissenting opinions. The majority found all of the 25 accused guilty of one or more counts of crimes against peace and war crimes. 7 of them received the death sentences, while the rest receiving varying terms of imprisonment. The death sentences were carried out on the 23rd of December 1948. Now, the Tokyo trial was maligned by its critics as victor's justice for much of the post-war period. However, the assessment of its legacy has undergone a marked change in the past 2 decades, by no small measure because of the growing global importance today of international criminal justice mechanisms to end impunity for genocide, war crimes, crimes against humanity, and other types of massive human rights violations. What exactly, though, did the Tokyo trial accomplish to make it relevant to our understanding of the international criminal justice regime today? Equally important, what does the Tokyo trial have to offer to help increase the role and visibility of Asia in furthering the cause of international justice and accountability? You may respond to these questions differently depending on what specific issues about international criminal justice takes priority in your mind. For instance, is it the understanding of the legacy of the Tokyo jurisprudence and criminal procedure to modern international criminal law that interests you the most? Or is it the development of a better appreciation of the Tokyo trial's role in documenting the history of Japanese war and war crimes? Or is it to explore the educational potential more broadly of the Tokyo experience to facilitate the dissemination of the principles of international criminal justice and accountability as universal values among the states and societies in Asia today? With respect to the first point, legal scholars today would generally agree that the Tokyo trial has less and less practical relevance to substantive law and criminal procedure of modern international law, given the massive case law literature that has grown out of more than 2 decades of trial experiences at the ICTY, ICTR, and elsewhere. That said, new lines of research on the law and jurisprudence of the Tokyo trial are being pursued by historians and legal scholars lately, these days. The outcomes of their new research initiatives are likely to help us gain a much more comprehensive understanding of the Tokyo legacy on such matters as interpretation and translation problems during the court proceedings, and the theorizing and application of the principle of superior responsibility. As to the second point, it is generally agreed among historians today that the massive trial record, which includes more than 48,000-page transcripts of court proceedings and several thousand items of court exhibits, constitute an incomplete yet critical body of oral and documentary history of the Japanese conduct of war and military occupation during the Asia-Pacific War. Furthermore, recent studies have revealed that the Tokyo Tribunal admitted voluminous evidentiary materials concerning sexual violence, such as widespread rape, sexual torture, abduction, and forced prostitution that were committed by the Japanese military at various theaters of war. These findings compel us to take into account the Tokyo experience when developing a historical understanding of the prosecution of sexual violence at the international criminal trials in the 20th and 21st centuries. As for the third point, as mentioned by Mao Xiao earlier on, the year 2018 offers a unique opportunity for us to use the Tokyo experience to disseminate the principles of international criminal justice and accountability in Asia, for the reason that this year marks the 70th anniversary of the deliverance of the Tokyo judgment. There is a keen interest internationally this year indeed to take a fresh look at the legal, jurisprudential, and historical legacies of the Tokyo trial. The International Nuremberg Principal Academy hosted just last week a 3-day international conference on the Tokyo trial and its legacy. As I see it, it is now the time for Asia scholars and Asia specialists in the particular in the relevant fields to carry forward the fresh dialogue that the Nuremberg Academy has kickstarted with the goal to promote among Asian countries the studies of the Tokyo trial as well as other more recent Asian international justice initiatives in East Timor, Cambodia, and so on, and cultivate partnership and collaboration among Asian countries for the strengthening of international criminal justice regime in the Asia-Pacific region. That's all. Thank you.